Welcome to the Lead Quick videos. Now in this video we want to do something very different. We want to go deep into the matters as it affects the Supreme Court judgment. Now this is coming out of the heels of the fact that the presidential elections have come and gone, and the opposing candidates have declared their interest and in fact have proceeded to the relevant court of law. And now, so we want to begin to shine the light on the Supreme Court, basically, because we know that at the end of the day, these court cases will find their way to the Supreme Court. And so let's give a brief background of the Supreme Court as it stands today, as provided for in our Constitution. We're going to be doing a lot of videos on this matter. We're going to be talking about the justices. We're going to be looking at how they have performed, how by dint of their judgment, by dint of their performance, how they have become famous or infamous. And so we're going to be doing a lot of series on the Supreme Court and the justices of the Supreme Court, so that we'll begin to put pressure on them, so that they will know that the eyes of the public are rested upon them as they perform their duties. And so we want you to join us in this campaign. We want to be with us, and one way you can be part of it, to help draw the attention of the Supreme Court and the judges of the Supreme Court to the fact that they must deliver judgment based on the principles of law and nothing less. And so one way you can be part of that campaign is by sharing this video to your contacts, calling attention of your friends and families to watch this video, so that they will be aware of what is to be expected from the Supreme Court. Now, we all have a role to do this. We have chosen this path to commit to providing you this information, because we understand that information is the difference between developing nations and developed nations, or between the rich and the poor. So let's begin this conversation with a brief background on the Supreme Court. And here is it. In 1963, the Federal Republic of Nigeria was proclaimed by the colonizers, that is the British, and Nnamdi Azikiwe became the first president. Now, appeals from the Federal Supreme Court for the Judicial Committee of the Privy Council were abolished at that very point, and that set up the Supreme Court becoming the highest court in Nigeria, because hitherto to this moment, appeals from the Nigeria Supreme Court, in quote, used to go to the Committee of the Privy Council, which is in Britain. And so by the abolishment of the Privy Council, the Supreme Court became the Supreme Court of Nigeria. Now, under the 1999 Constitution, the Supreme Court has both original and appellate jurisdictions, and it has the sole responsibility, or rather the sole authority and jurisdiction, to entertain appeals from Court of Appeal, having appellate jurisdiction over all lower federal courts and highest state courts in Nigeria. Now, the Supreme Court plays a very important role in our constitutional democracy. There is no two ways about that. Now, the first role that it plays as the highest court in the land, it is the court of last resort for those looking for justice. And that is why we can anticipate that as these opposing parties look out for justice in the 2023 presidential elections, it's going to eventually get to the Supreme Court. Now, decisions rendered by the court are binding on all courts in Nigeria except the Supreme Court itself. And so what it means is that the Supreme Court, as we have seen in the past, we will come to that point where we will give you the background information of how the Supreme Court also is capable of reversing its judgment they can reverse his judgment. We have a precedent on that. And so when you appeal to the Supreme Court and lose your appeal, you can only appeal to God, because it is the final court of the land. Now, the second responsibility that the Supreme Court have in our constitutional democracy is because of its power of judicial review. It plays an essential role in ensuring that each branch of government recognizes the limits of its own power. We have also seen this play out very recently. We'll come to that point. Now, example is the case brought before it by the three state governments against the federal government and the CBN on the new Naira redesign policy. We are all aware of that. Now, thirdly, the Supreme Court protects civil rights and liberties by striking down laws that violate the Constitution. They strike down laws that violate the Constitution. And finally, it sets appropriate limits on democratic governance by ensuring that popular majorities cannot pass laws that harm or take away or take advantage, undue advantage of unpopular minorities. Now, in summary, the Supreme Court serves to ensure that changing views of a majority do not undermine the fundamental values common to law, like freedom of speech, freedom of religion, and due process of law. Now, like we have said, as the opposition parties in the 2020 general election move the election to the court of law and ultimately to the Supreme Court to seek legal redress on the perceived or real transgressions perpetrated during the election, we will be doing a series on the Supreme Court to shine a spotlight on the justices and their actions now and in the future, now and in the time past, to be able to understand the future and whether there will be justice for the people. Now, the first in the mini series that we're going to be doing on the Supreme Court and the justices is to look at, the governorship cases that got the Supreme Court judgment and how the justices delivered those judgments, to be able to understand a pattern, to be able to establish the pattern of judgment in the Supreme Court, to form an opinion whether the Supreme Court will be capable of giving justice to the people. We'll be able to identify the consistency, of these justices in delivering their judgment. And so in this video, we are going to be giving you the 5 state governors that have benefited from the Supreme Court judgment. And we're going to try to dissect the issues, the water that passed under the bridge, and leave you to make an informed opinion of those judgments. I won't let the cat out of the bag at this point. I want you to just pay attention and follow us to understand the minds of the justices while they delivered those judgments. And so we're going to start with the first case, because we are going to start from the, we started this republic, this third republic, or is it fourth republic now, from 1999. Okay, and so we're going to go back, from that time to see, how those cases arrived at the Supreme Court and what the Supreme Court did. Now, you must understand there are some other cases that involve governorship cases that went to the court, but they did not proceed to the Supreme Court. Now, that is because there are different categories of cases that can proceed to the Supreme Court. Cases that have pre-election matters, cases that, governorship cases that have pre-election matters are expected to be concluded at the appeal court. Now, whereas cases that are involved during the electioneering process, that is cases that does not involve primary election litigations and all that, can proceed to the Supreme Court. And so this is why from 1999 to date, the cases we are going to be giving to you involves only 5 state governors from 1999 to date, which were able to proceed to the Supreme Court. I believe you understand what we're saying now. So the first case that we're going to be looking at is the case of Mr. Peter Obi versus Andy Uba. Now, how did this case happen? Now, Mr. Peter Obi contested elections in the Anambra State 2003 governorship election. Now, the electoral authority, which is INEC, declared the election to have been won by another candidate in the person of Dr. Chris Ngige, now who is the current Minister of Labour and Productivity. Now, accordingly, Ngige was sworn in as governor in 2003 under a term to run for 4 years as provided in the Constitution. Now, that is supposed to end in 2007. However, Mr. Peter Obi challenged Dr. Chris Ngige's victory in the courts. Now, with ultimate success in 2006, when it was finally heard that the election of 2003 had in fact been won by Peter Obi. Now, as a result of the Supreme Court decision, Ngige was ordered to vacate the office for Obi. Now, following his success in the courts, Obi was sworn in as governor of Anambra State. Now, this is why we pick this case. We're not talking more about, the case between Obi and Ngige. What resulted, because it was a straightforward case about manipulation of election results. Okay, so we have similar cases like that, manipulation of election result. We're going to be talking about, but we try to focus on this very case because of the complications in the case, which is the case between Peter Obi and Andy Uba. Now, because after Mr. Peter Obi took the oath of office, the oath of allegiance and oath of office on March 17, 2006, okay, election was now conducted in 2007. Okay, now remember, Peter Obi is supposed to do another 4 years, but Dr. Ngige has almost completed his 4 year in office. Okay, so by the time Peter Obi came into the office and spent about 1 year thereabout, another election was conducted, which Dr. Andy Uba won that election, and of course he is expected to also be sworn in, because the election that Mr. Peter Obi won was the same election that was conducted for all governors across the country, across the 36 states of the Federation, and which were all supposed to terminate at the same time in 2007. But Mr. Peter Obi was only sworn in March of 2006. So the issue that became, who will be the governor? There cannot be two governors in one state house, in one state. And so you cannot have Peter Obi and Andy Uba becoming the governor. And so the case proceeded to the court. Now, the expectation was that the term of office of each state governor elected in 2003, like I said, was to end in 2007, when fresh governorship elections would once again, be conducted for the 36 states of the constitution of the federation. Now, in other words, the expectation in ordinary circumstances is that all the governors will be elected in the same year, and their term to run and end at about the same time of 4 years. So while Peter Obi's case was yet to be decided by the Supreme Court, governorship elections were held in 2007, reflecting the normally expected end of terms of the governors elected in 2003. And Andy Uba, like we said, was declared to be the winner of that governorship election in Anambra State. So the major issue is, how will this thing play out? Who will be the governor? Will you allow Peter Obi to continue to be in office for the next 4 years starting from 2016, or will you now ask Obi to vacate the office after spending just 1 year or less in the office for Andy Uba to be sworn in as a governor? So, as an issue of general principle and observation, to conclude that Obi's term started from March 17, 2006 will automatically place Anambra State out of political step with other 36 states other 35 states of the Federation. Now, in that governorship election in Anambra State, could be only held 3 years after the latest governorship elections in the other states. So, however, the Supreme Court's primary, purpose, of course, is to interpret the law, and the primary provisions that the Supreme Court had to interpret were the provisions of Section 180, subsection 1, and Section 180, subsection 2 of the Constitution. Now, this provision states that Section 180, subsection 1 states that subject to the provision of this Constitution, a person shall hold the office of governor of a state until A, when his successor in office takes the oath of that office. When his successor in office takes the oath of that office. So who is the successor in this question now? Or when the governor dies while holding such office, or when the state, when the date of his resignation from office takes effect, or when he otherwise ceases to hold the office in accordance with the provisions of this Constitution. Now, subsection 2 states that subject to the provisions of subsection 1 of this section, the governor shall vacate his office at the expiration of a period of 4 years, commencing from the date when A, in the case of a person first elected as governor under this Constitution, he took the oath of allegiance and oath of office, and B, the person last elected to that office took the oath of office, or the oath of allegiance and oath of office, or would, but for his death, have taken such oaths. So these are the provisions of these sections of the Constitution that the Supreme Court had to interpret to give judgment on the issue between Peter Obi and Anduba. Now, the principal focus of the judgment of the Supreme Court is Section 180, subsection 2, which provides that the governor shall vacate his office at the expiration of 4 years from the date he took the oath of allegiance and oath of office. Now, on an obvious literal interpretation of this provision, the court took the view that as Peter Obi was sworn in as governor of Anambra State on March 17, 2006, his term of office does not end until March 17, 2010. So you see that the Supreme Court actually, decided this case based on the literal meaning or literal provisions of the Constitution, and that gave Peter Obi victory against Dr. Anduba and made Peter Obi to become governor. Now, the next case we want to look at is the case of Rotimi Amechi versus INEC. I know many of us will remember Obasanjo, President Obasanjo, and the famous K-leg candidate. Okay, and so a brief background of this case was that Amechi contested the primaries, okay, as a member of PDP in his quest to be the governorship candidate of the party in the April 2007 elections in Rivers State. Now, he contested against 7 other members of the PDP. They competed for a total of 6,575 votes. Amechi had 6,527 votes to emerge the winner. Now, one of those other 7 candidates or 6 candidates is Omehia. Now, Omehia was not one, among those other 7 candidates, Omehia was not one of the candidates at the PDP primaries. Now, after the primaries, the PDP submitted Amechi's name to INEC as its governorship candidate. Now, I want you to pay attention to this. There were 7 of the primary contenders for the ticket of the PDP. In all of these 7, Omehia, who you will know more about as we progress in this case, was not part of the 7 contenders for the primaries of the PDP ticket in 2007. And so now Amaechi was submitted to INEC as a governorship candidate. Meanwhile, no court of law after that primaries made an order disqualifying Amaechi so far from contesting the governorship elections. But out of the blues, PDP substituted Umeha's name for Amaechi without giving cogent and verifiable reasons for the substitution as required by the Electoral Act 2006. And so Amaechi, therefore filed a suit claiming that he is a right candidate and therefore sought relief of the court to give the following orders. Now, one of the orders that Amaechi sought for was number 1, a declaration from the Supreme Court that the option of changing or substituting a candidate whose name is already submitted to INEC by a political party is only available to a political party and or the Independent National Electoral Commission, INEC, under the Electoral Act 2006, and it's only if the candidate has been disqualified by a court order. And in this case, no court order has disqualified Amaechi. Now, Amaechi sought a second relief, that a declaration be made that under section 32 subsection 5 of the Electoral Act 2006, it is only a court of law by an order that can disqualify a duly nominated candidate of a political party whose name and particulars have been published in accordance with section 32 subsection 3 of the Electoral Act 2006. He sought the third order, that a declaration be made that under the Electoral Act 2006, Independent National Electoral Commission (INEC) has no power to screen, verify, or disqualify a candidate once the candidate's political party has done its own screening and submitted the name of the plaintiff, in this case Amaechi, or any other candidate, to the Independent National Electoral Commission. He went ahead again to seek for, the fourth relief, that an order be declared that the only way Independent National Electoral Commission can disqualify, change, or substitute a duly nominated candidate of a political party is by court order, and that under section 32 subsection 5 of the Electoral Act of 2006, it is only a court of law after a lawsuit that a candidate can be disqualified, and it's only after a candidate is disqualified by a court order that the Independent National Electoral Commission can change or substitute a duly nominated candidate. He sought for another order to declare that there are no cogent and verifiable reasons for the defendant, in this case now the INEC and Umeha, to change the name of Amaechi, which is the plaintiff, with that of the second defendant, which is Umeha, as a candidate of the PDP for the April 13, 2007 governorship election in Rivers State. He sought for another order that a declaration be made that it is unconstitutional, illegal, and unlawful for the first and 10th defendants, that is Amaechi and INEC, to change the name of Umeha and INEC to change the name of Amaechi with that of Umeha as the governorship candidate of PDP for Rivers State in the forthcoming, or rather in that 2007 governorship election. Now, after the plaintiff have duly nominated and sponsored by the PDP as his candidate, and after the first defendant has accepted, that is INEC has accepted the nomination and sponsorship of Amaechi and published Amaechi's name and particulars in accordance with section 32 subsection 3 of the Electoral Act of 2006. Now, INEC failed to give any cogent reason, as we have said, for the disqualification of Amaechi. Now, in all of this, Amaechi now requested that the Supreme Court make a perpetual injunction restraining both INEC and Omehia to jointly or severally by themselves, their agents, privies or assigns from changing or substituting the name of Amaechi as the Rivers State People's Democratic Party governorship candidate for the election in Rivers State, unless or until a court order is made disqualifying Amaechi, or until cogent and verifiable reasons are given as required under Section 34, subsection 2 of the Electoral Act of 2006. Now, you can see from all this relief that Amaechi took to the Supreme Court, they were very clear, very clear to even the layman. And so, at the end of the day, the Supreme Court delivered its judgment in favor of Amaechi. Now, the next case is that of in Kogi State, the case of Faleke versus Yaya Bello in the 2015 gubernatorial election for Kogi State. Now, in that election, the APC fielded Prince Awudu Abubakar as his gubernatorial candidate with Mr. James Faleke as his running mate. Before the election could be completed, as INEC was yet to declare the winner of that election, Prince Awudu Abubakar, who was the governorship candidate for the APC, died, leaving a vacuum as the lead person in the governorship ticket of his party. Now, ordinarily, it will be assumed that it will be expected that his deputy, James Faleke, will automatically step into his shoes, to continue the race to the government house. But because the election was also declared as inconclusive, other parties contesting in the election quickly challenged the notion that the votes for the dead governorship candidate, who was the lead person in the ticket, cannot be transferred to the deputy governorship candidate. And so the parties were seeking for a way to nullify those votes, and so that it can put them in a better position of winning the election. And so the stage was set for legal fireworks. Now, on one hand, the deputy governorship candidate in the person of Mr. James Faleke, who was deputy to the dead Awudu, was claiming that the election has been won and lost before his principal, the governorship candidate, died. But the other parties, were contending that it cannot be so. So it became an issue. So to be on the safe side, the APC, who fielded Awudu Abubakar, Prince Awudu Abubakar, and James Faleke as a governorship and deputy governorship candidate, quickly, as they were going to court, quickly, they requested the court to replace the dead Awudu with the person, to replace dead Awudu in the governorship ticket with another of the APC contestants for the primaries of the governorship ticket for APC, in the person of Yaya Bello, who contested the primaries and lost to the dead Prince Awudu Abubakar. And so, on one side, you have James Faleke of APC contending to be the one that will continue the ticket of Prince Awudu and Faleke. On the other hand, you have APC contending that Yaya Bello should replace the dead Awudu, the dead Prince Abubakar Awudu on the ticket of the APC. And on the other hand, you have other parties contending that the votes for APC be declared null and void because the lead person in the ticket, the person of the governorship candidate in the ticket, has died. And so the case traveled from appeal court to the Supreme Court. Now, at the appellate court, among other things, the appellate court said that Faleke, whose joint ticket with Awudu had garnered 240,000 votes and 240,873 votes before Awudu died. However, he could not benefit from James Faleke could not benefit from those votes or take the place of Prince Awudu Abubakar because he did not meet the condition of a governorship candidate president, which is for him to have been nominated by his party, for that governorship as the governorship candidate of the party. So in that reason, in the reason given for the summary judgment delivered by the court, Justice Kudirat, Kekere Ikun, who delivered that judgment, he did not obtain nomination form. He did not participate in the primary election, and as such, he could not, under any circumstances, be made the governorship candidate to replace Awudu. Now, besides, she said that before the sudden death of Awudu, after the November 21 governorship election, the Independent National Electoral Commission had already declared the election to be inconclusive, and that since the election had not been completed and the result issued by the electoral body, Faleke, as a running mate, could not claim victory in the election. Now, the Apex Court upheld the replacement of Awudu with the Yahaya Bello, because in the face of the law, Bello obtained nomination form, took part in the primary election, and came second, unlike Faleke, who did not meet that condition. And so the Supreme Court said that by virtue of section 221 of the 1999 Constitution, Bello, that is Yahaya Bello, having become the candidate of APC and legally sponsored by the same party, in the face of the law, could lay claim to the votes of 240,857 that was cast for the party in that very 2015 governorship election. And therefore the court said that the provision of section 221 was clear, that it was political parties that canvass votes and be voted for in the elections, and that it was only candidates duly sponsored by the political parties that could claim to such votes of their parties. In the instant case, the court insisted that Faleke, having not been sponsored as a governorship candidate by APC in the supplementary election of 2015, could not lay claim to the votes of that election and the result of the election. And that was how the court dismissed Faleke's petition for lacking in merit and upheld the nomination of Bello as a replacement for Awudu, and his subsequent declaration by INEC as the duly elected governor of Kogi State. Interesting judgment, very interesting judgment. And so these are legal cases that the Supreme Court adjudicated very equitably, focusing on the extant provisions of the Constitution. And so we really commend them for some of these interesting judgments. Now the next case is that of Ihedioha versus Uzodinma in Imo State. This is another very interesting case. Now, whereas in the governorship election of 2019 in Imo State, Ihedioha of the PDP scored 276,404 votes and was declared winner of the March 9th, 2019 state governorship election for Imo State by the INEC. Senator Hope Uzodinma, on the other hand, of the All Progressive Congress, came fourth in that election with just about 96,458 votes. However, by the token of the judgment of the Supreme Court, Senator Hope Uzodinma is the current governor of Imo State. How did someone that came fourth in a governorship race became the governor of a state as we speak? This could mean serious legal implications. So what happened? Now follow us and let's see what happened. Now, after the election and Ihedioha was declared winner, the other contestants in the election approached the Court of Appeal to void the election of Mr. Ihedioha on grounds that he did not obtain the constitutional 1/4 of the votes in at least 2/3 of the 27 local government areas of the state, in line with section 179 of the Constitution, which is a very valid matter. Okay, very valid and straightforward matter. Now, meanwhile, Uzodimma, who came forth, sought the court judgment to declare him the winner of the election, because according to him, the votes from 388 polling units that was meant for him was excluded in INEC's result. But the appeals court disagreed with them and upheld Ihedioha's election. Now, these appellants then approached the Supreme Court, and that is why it is very interesting for us. Now, at the Supreme Court, INEC, in the reply, because at the Supreme Court, other appellants matter, were dropped. Okay, and so it was leaving majorly that of Ihedioha versus Uzodimma. Now, in their reply to Uzodimma's petition, INEC disowned those result sheets that was tendered by Uzodimma's legal team, and insisted that no results were generated from those polling units, as elections in those polling units were cancelled by the presiding officers because of violence, overvoting, snatching of electoral materials, and among other challenges that was faced by the election officials in those 388 polling units. Now, which is normal, which the presiding officers are empowered, INEC is empowered to do, to cancel results, whenever they confirm that those elections did not meet certain standards. And so the INEC stated that any result from those polling units presented by any of the candidates, and in this case in particular Hope Uzodimma, that the petitioners by the petitioners must be fake. That is to say, any result sheet tendered by any legal team from any of the petitioners must be fake, because they did not issue any of those results. Now, even when the purported polling agents were called to testify to the result sheets from the 388 polling units, information from the trial sessions show that they were unable to ascertain the veracity of the document. But guess what? The Supreme Court accepted those results from the supposed cancelled polling units, added them to Uzodimma's declared votes, and ordered INEC to issue certificate of return to Uzodimma, making Uzodimma the governor of Imo State. And so, as we speak, this is an issue that generated a lot of concern, and legal experts are still trying to come to terms with what were the criteria, what were the the legal reasons that INEC used to inform this decision. And so we leave that for you to also chew. But the next one we want to talk about now is the one that happened in Bayelsa State, which is Degi versus PDP in the 2019 governorship election in Bayelsa State. Now, the PDP featured Doyediri, while the APC fielded Degi Eremeyo. I don't know if I got that name very correct. Okay. Now, after the election, PDP and its governorship and deputy governorship candidates challenged the victory of APC, because in that election, INEC declared Degi, the candidate of the APC, as the winner. And so PDP challenged that election as presented to challenge that election, that the candidate of APC, Degi Eremeyo, presented to INEC documents of academic qualifications with about 9 variations of names different from the name that appeared in his form CF001, which was submitted to INEC. Now, the court filings show that the APC candidate claimed to have obtained his first school leaving certificate in 1976 and presented to INEC a first leaving school certificate of one Degi Kyobaraga, other than the one bearing his name of Eko Baraga Degi Eremeyo, as shown in his INEC form CF001, and presented to INEC a GCE certificate of one Adegi Eibaku, other than the one bearing his name of Biobarakuba Degi Eremeyo, as shown in his INEC form CF001. Now, delivering the judgment of the Supreme Court, Justice Ejembi Eku, who read the lead judgment of the Appellate Court, made the orders after disqualifying the APC deputy governorship candidate Degi Eremeyo as a candidate in the election. Justice Eku disqualified Degi Eremeyo's candidacy on the grounds that he presented false information about his educational qualifications in his form CF001 submitted to INEC as a candidate for the 2019 elections. The court therefore upheld the November 12, 2019 judgment of the Federal High Court in Abuja, which had disqualified Degi Eremeyo in the election for submitting forged certificates to INEC. The court ruled that Degi Eremeyo's disqualification based on submitting false information to INEC had infected the joint ticket with which he and David Leon, the deputy governorship candidate, contested the election and emerged victorious. Now, from the foregoing, we can attest that the Supreme Court has been consistent in adjudicating the law using the provisions of the law, with some few exceptions, which is, in the case, especially in the case of Imo State governorship election, where it was said to have relied on importation of evidence which INEC did not make provisions for. And so, for you as a Nigerian, what do you think with this trend of judgment? Do you think the Supreme Court will be fair in this current dispensation, especially as the parties in the 2023 general presidential election has proceeded to court? Tell us what you think, and watch out for the next series, which will focus on the presidential elections judgments as delivered by the Supreme Court. In this edition, we have looked at the judgment of the Supreme Court as it has to do with governorship elections. In the next series, we'll be looking at the presidential elections. I want you to join us and share this video so that Nigerians will be more aware about the Supreme Court, the justices, and their actions.